being understood to refer to the claimant. The said words do not and were not understood to bear the meanings alleged in paragraph 2 of the particulars of claim or any defamatory meaning. The said words were not calculated to disparage the claimant in his profession or office, trade, calling or business as alleged in paragraph 3 of the particulars of claim or at all. It is denied that the claimant sustained the loss and damage alleged in paragraph 4 of the particulars of claim or any loss or damage by reason of the publication of the words complained of herein. B. Libel. Save that no admissions are made as to the circulation or readership of the said newspaper, paragraph I of the particulars of claim is admitted. The defendant denies that he wrote, printed, or published or caused to be written, printed or published the words set out in paragraph 2 of the particulars of claim or any of them. It is denied that the said words referred or were understood to refer to the claimant. It is denied that the said words bore or were understood to bear or were capable of bearing the meaning set out in paragraph 4 of the particulars of claim or any defamatory meaning. Save that the defendant does not admit the word enormous, paragraphs 1 and 2 of the particulars of claim are admitted. It is admitted that on pages 6 and 7 of the Sunday Correspondent for May 3, 2008, the defendant published an article which included the words pleaded in paragraph 3 of the particulars of claim. The said words formed part of a much longer article to the whole of which the defendant will refer for the context and true meaning of the words complained of. It is denied that in their natural and ordinary meaning the said words, in their proper context, bore or were capable of bearing the meanings or either of them pleaded in paragraph 4 of the particulars of claim. If and in so far as the said words in their natural and ordinary meaning bore and were understood to bear the meanings set out below, they were true in substance and in fact. That the claimant has been guilty of a reprehensible lack of parental responsibility by abandoning the child he had by his mistress. That the claimant is a hypocrite for making public pronouncements which are not matched by his own private behavior. Particulars of justification. The claimant has been a member of Parliament since 1984. As pleaded in paragraph 1 of the particulars of claim, between May 2002 and April 2007, he served in the government as an Undersecretary of State for L. In that capacity, he made a number of speeches in Parliament 40 and in public in which he espoused the cause of Back to Basics, a social policy which called for a return by society to traditional family values and placed a strong emphasis on parental responsibility. The claimant published a book containing autobiographical memoirs, entitled Personal Reflections, in or about date. In the said book, there are a number of passages in which the claimant articulated his conviction that the root cause of various forms of social malaise was the dereliction by parents of their duties towards their children. Parents must be accountable to society. p. 120. The defendant will refer to and rely upon all these passages at trial, but for present purposes simply refers to the page and paragraph number of the relevant extracts. At a press conference held on April 1, 2007, the claimant announced that he had had a sexual relationship with his former employee, a researcher named Ms. Jan Smith, now Mrs. Brown, and that on June 7, 2004, she had given birth to a son, John, of whom he was the father. Notwithstanding and in flat contradiction of his previously adopted stance, at a further press conference on April 15, 2008, the claimant stated that he intended neither to take an active role in the upbringing of his son nor to make any financial provision for him. The purported ground for this conduct was that he did not wish to interfere in the relationship of Mrs. Brown with her husband, who were happy to treat the child as their own. Further or alternatively, insofar as the said words made or contained the following comment or expression of opinion, namely that the claimant had behaved in a callous, hypocritical and reprehensible manner towards Mrs. Brown and his son, the defendant contends that the said words constituted fair comment on a matter of public interest, namely the propriety or otherwise of the conduct of a member of the government whose private behavior towards his own family stood in stark contrast to his public pronouncements on the issue, at a time when he had direct responsibility for governmental policy on issues relating to Social Security. Particulars of fact upon which comment is based. 1. the defendant repeats paragraphs 4, 1, 2, 4, above, further or alternatively. Insofar as the words contain the comment or expression of opinion set out in paragraph 5 above, they were fair comment upon a matter of public interest upon the following facts which were stated to have been found proved in the judgment of Mr. Justice just given in open court on May 8, 2007 in wardship proceedings in the Family Division of the High Court of Justice in London in the case of J, a minor, which related to the claimant's son, a fair and accurate report of which was published on page 5 of the same issue of the said newspaper. Particulars of fact upon which comment is based. In his judgment dated May 8, 2007, Mr. Justice just found that, set out particulars of all relevant facts found to have been proved. The defendant will rely, if necessary, upon the provisions of sections 5 and/or 6 of the Defamation Act 1952. No admissions are made in respect of paragraph 5 of the particulars of claim. If the claimant is entitled to any award of general damages, which is denied, it is denied that the claimant is entitled to an award of aggravated damages thereon by reason of the facts and matters alleged in paragraph 6 of the particulars of claim or otherwise. The defendant will rely upon the following in answer to the matters alleged in paragraph 6 of the particulars of claim. Set out all relevant matters which, I, meet and answer the allegations being advanced by the claimant in support of his claim for aggravated damages, or, 2, demonstrate that the claim is misconceived in fact and/or in law, e.g. 9.1 It is untrue that the defendant prepared and published the article without making any attempt to verify the facts with the claimant or afford him any opportunity to comment on the proposed publication. On 4 separate occasions on Friday, May 2008, Ms. Peterson of the defendant telephoned the claimant at his office in Millbank at Westminster to seek the claimant's comments on the proposed publication. Ms. Peterson was informed through the claimant's secretary that he was not willing to discuss his personal life with the media. 9.2 Further, even if those attempts had not been made, the alleged failure to contact the claimant would not have been a justified ground of criticism of the defendant because the claimant stated at the press conference held on April 15, 2008 that he was not prepared to discuss his private life further, in particular, the arrangements he had made for his son with Mrs. Brown, with the media. 10. If, which is denied, the claimant is entitled to any damages. In mitigation of those damages, the defendant will rely upon the fact that the claimant has brought a claim and has received compensation for damages for libel in respect of the publication in the Rockford Times newspaper of date of words to the same effect as those complained of in this action. 11. By reason of the matters pleaded above, it is denied that the claimant is entitled to the injunctive relief he claims against the defendant in paragraph 7 of the particulars of claim. Save that the defendant avers that the claimant was summarily dismissed from his employment with International Finances Incorporated on June 7, 1988 and from Jodrell Bank on date, in each case for gross misconduct, paragraph I of the particulars of claim is admitted. Save that no admissions are made as to the precise size of the circulation or the influence commanded by what's happening in finance, paragraphs 2 and 3 of the particulars of claim are admitted. It is admitted that the defendant published in the issue of the said journal for date the words set out in paragraph 4 of the particulars of claim. It is admitted that the words complained of bore and were understood to bear the meaning alleged in paragraph 5 of the particulars of claim. The words complained of consisted of a fair and accurate report of legal proceedings in public brought against the claimant and accordingly were published on an occasion of qualified privilege. Particulars. In criminal proceedings which came on for trial at the Central Criminal Court, Old Bailey, London on May 31, 2008. The claimant was prosecuted for 15 separate counts of theft contrary to Section 1 of the Theft Act 1968 in connection with the disposal of International Finances Incorporated's assets to a number of bank accounts held offshore in Bermuda in his name and/or in the name of shell companies incorporated by him. On June 25, 2008, the claimant was convicted on 2 of the said counts of theft which related to the misappropriation by him of sum E120,000 of his client's investments, and was sentenced to 2 years imprisonment, suspended for 2 years. To the extent that the words complained of referred to the said criminal proceedings against the claimant. Namely, the headline, paragraphs 1 to 12, and 20 to 23 of the article complained of, they constituted a fair and accurate report of the said proceedings which took place in public before a court in the United Kingdom. Accordingly, the said words are protected by qualified privilege under Section 15 of the Defamation Act 1996, being a statement within the meaning of Part I, 2, of Schedule 1 thereto. Further or alternatively, in the natural and ordinary meaning contended for by the claimant and admitted by the defendants in paragraph 4 above, the words complained of are true in substance and in fact. Particulars of justification. I set out facts and matters which establish that the words complained of are true in the meaning which the defendants have accepted they bear. The defendant repeats paragraphs 5.1 and 5.2 above. Further, if and insofar as may be necessary,